You're listening to Beyond Borders, the Immigration Evaluation Podcast, the go-to podcast for mental health professionals who want to be expert immigration evaluators. I'm your host, Dr. Mariela Shibley, and I'm here to help you turn your expertise into impact. Let's get started. Hi, everyone, and welcome back to the podcast. I'm so excited for today's episode because we have a very special guest joining us, someone who brings a wealth of insight and experience in the field of immigration law. Jacob Sapochnick is the managing attorney at the law offices of Jacob J. Sapochnick and a longstanding member of the American Immigration Lawyers Association. He's lectured internationally on immigration law topics, written extensively for various publications, and is widely recognized for his expertise in U.S. business immigration. With a legal background that spans both the UK and the U.S., Mr. Sapochnick supports clients from around the world, helping individuals, professionals, and companies navigate the complex process of living and working legally in the United States. He's been quoted in global media, published an ebook on TN visas, and regularly speaks at major immigration and career events, including the San Diego Career Expo. So if you're a clinician who conducts or is thinking about conducting immigration evaluations, this conversation is going to give you real valuable insight into the legal side of the work that we do and how to collaborate effectively with attorneys. So let's get into it. All right, Jacob. Well, thank you so much for joining us. This is such a treat. So I want to start with sort of the big picture from your legal perspective. What role does a psychological evaluation usually play in an immigration case?
So, I think there's definitely a variety of different cases, but I think the evaluation helps the immigration officers to kind of start forming an opinion about, first of all, whether the client will qualify for the benefits that they are applying. So whether it's an U visa or a T visa or a 601 waiver, all these things have legal requirements. And I think the evaluation kind of pushes the officer into the direction that hopefully will get them to give a favorable recommendation in the case. So it kind of almost like sets the scene as to what is this person about and where are they going to with their case.
Mm-hmm. Mm-hmm. And so clinicians often ask me, like, what makes a good report? So sort of from your perspective, what really makes the psychological evaluation effective or, on the flip side, problematic?
So I think an effective report has some sort of a description of who we're dealing with, a little bit of the background of the person, who they are. So the officer and whoever reads it form an emotional connection with the applicant. Then there should be an area where they explain the benefit. So in this case, let's say we focus on the hardship. In all of these cases that we do for the waivers, the hardship is a legal term. So typically when we work with the clinician, we tell them, listen, what we need in the report is to show that there's a progression in how they are impacted by this. So at the conclusion of the reading, the officer will determine that it's beyond normal inconvenience they're suffering from, whatever they're suffering. It actually comes to a hardship because, they're not able to work in this country. That creates anxiety, or they haven't seen their partner for a while. That creates separation, or the knowing that they're going to have to go and live in this foreign country creates panic attacks. So we want to show it in a reasonable way that there's the background, there is the story, there's the benefit, and then it shows how it impacts the applicant. And make it not too long in the sense that it's deep enough, but it's not too overwhelming where the officer might not even read it and miss the core elements of the evaluation.
Okay, great. Because now I have two questions stemming from that are very pointed questions. One is, you said hardship is, in these cases, is a legal term, right? Even though it's common language. What do you think of clinicians using the word hardship in a report?
So when I say legal term, I mean that the actual term is called extreme hardship. Right?
That's
It's
right.
an actual legal term. It appears in the Immigration Nationality Act. There's a definition for it. And so when I usually work with a new clinician, that will actually explain to them what it means in simple terms. So they understand that we need to show that it's beyond what is normal for somebody to feel frustrated or They feel that there's hardship, right? And then we need them to be able to show by their analysis how they reach the conclusion that this person actually will be suffering extreme hardship, right?
Mm-hmm.
And so that's what I mean by that.
If they wrote, so based on all this, it's my professional opinion that this person would experience extreme hardship as a result of a
Right.
separation. What do you think of a clinician using those words in the report? Do you think it's overstepping because that's not for us to determine, that's for the adjudicator to determine? And so therefore it's almost like crossing over the line beyond the scope of our expertise, or you don't think it's a big deal?
Well, I don't think it's a big deal. However, what is important right now, people are looking and saying, well, how did the clinician reach this conclusion? And so before we make that determination, I always tell them, well, you can say that, but before you say that, why don't you give a couple of examples? So then the officers say, oh, wow, this has happened. So she had these panic attacks, or she fainted multiple times, or whatever that is. So then the officer understands, oh yeah, that's the reason why, we determined that it's extreme hardship. And that will help a lot, because if you think about it, who is the audience? Our audience are not people that are PhD scientists. These are government officials. They've been doing this for a while. They have a lot of experience. They've seen many of these cases, and they have emotions. And so the best evaluations are the ones that appeal to their emotions, are not too complicated, and make it easier for the officer to see the conclusion.
Right. Now, but I imagine there's a fine line between eliciting emotions and sounding like an advocate, right? Because we want to be seen as a neutral, objective evaluator and not as an advocate. You're the advocate, right? You're representing the client. So it'd be interesting to find that balance, right? To elicit that emotion, to really show the hardship while at the same time maintaining sort of your objectivity as a clinician.
Right. And the only way it's possible is by showing the officer what was the conversation about, maybe some of the tools that you use to reach to the conclusion this person is depressed, or they are showing signs of dependency, or whatever that is, so they can see that it wasn't just the opinion of Mariela or whoever is the evaluation person, but it is actually based on these facts.
Objective findings.
Correct.
Right. And you mentioned something about the length of the report. I have quite strong opinions about the length of the report, but I would love to know what you think, like what would be appropriate length.
Well, I mean, again, this answer might change from time to time, right? But right now, what we see is that sometimes it's very hard for us to work with evaluation professionals, because it also depends on where we are sending the case. So if most cases they go to, let's say, Ciudad Juarez, then I know that most of these officers are getting a little bit anxious once they see a report that is more than 6 pages, right?
Mm-hmm.
So anything more than 6 pages in Ciudad Juarez becomes almost a liability, because we don't know if they're going to read the whole thing, right? And then I know this because once or twice a year, we go to conferences where we have government officials who are on the panel on the other side, and they'll tell us, they'll say, well, we are now not going to read anything more than so-and-so, or if you give us these kind of supporting evidence, it's going to be very difficult for our agents to be able to see it. So I think anywhere about the 6 pages is a good foundation, because you have enough ability to give the test information, what is the actual going on with the background of the client, and give an actual opinion, versus like, let's say 3 pages only, it might be a little bit too short. And if it's like 20 pages, who knows if they're going to reach to the critical point of conclusion. You know what I mean? So I think like 6, by my mind,
Yeah, no, I absolutely 100% agree with you. Our reports are 6 to 8, depending on the type of evaluation, type of case. But you mentioned, like, again, I always tell people, write for the reader, right? And this is exactly what you're saying too. You know, these officers in Ciudad Juarez, you know they're not going to sit with a cup of tea and read a 20-page report. They're just not going to do it, right? But perhaps if the case is going to court, or if the case is likely that it's going to end up in the Board of Immigration Appeals, then you probably want a little bit more information. And so that would warrant a little bit, perhaps more extensive report.
Exactly. So if the case goes to court as part of the exhibits of a brief, 100%, maybe we need a little bit more depth, maybe we need to emphasize a little bit more things. If it goes to an appeal, then obviously there's more, so I agree with you. But if you're looking at the general reasons why most attorneys are using it, they'll go to consulates, they'll go to USCIS, and those within that length.
Excellent. Yeah. If you're looking to add a high-impact, high-income service to your practice, I've got something for you. Head to the link in the description box to check out my expert training in immigration evaluations, a comprehensive program designed to help you confidently conduct immigration evaluations, connect with attorneys, and build a sustainable practice. Now let's get back to the show. All right, so even strong reports can sometimes run into legal hurdles, right? So what kinds of challenges or pushback have you seen in court or with USCIS, especially across different case types like waivers or asylum or U visas, T visas? What have you noticed?
So I think, again, what we see now, we haven't seen before. Right now, we've seen more pushback as to, for example, with some recent U visas where we needed to have some reports about the state of the individual. We've seen immigration officers are not giving credit to these evaluations. They're saying that they're too generic. They're not very specific. We've seen reports, a recent court case where a judge wouldn't accept the evaluation, saying that, well, accept it, but didn't give enough credit, saying that it was too generic and he couldn't believe that a professional was able to make an opinion about the person's state of mind by only speaking with him 3 times. Another case we've seen for a waiver case, this was in Poland, a European embassy, where we were able to show that the person is, she was severe depression and also panic attacks. She wasn't able to stay alone for more than a few hours a day. The reason why we wanted to prove that is because we wanted to show her need to be with family members, because, if she has to leave, then everybody's there. So it was a very critical point. And the consular officer said that the fact that the report was so in-depth, but the client itself couldn't prove any consistent mental treatment, that she wasn't going to see a therapist on a regular basis, negated that report, saying, well, if she's so bad, why is she seeking therapy? Why wasn't she in therapy before? And where is the proof she will go to therapy in the future? Do you know what I mean? So it was a really good report, but the consular attacked it by saying that, well, we don't think that the client is that bad, because otherwise she would have already shown us where's our medications. You know what I mean? So things like that we're now aware of. We are more aware of those things. So before we even send somebody for evaluation, we already tell them, well, let's make a plan, because that evaluation itself is not going to be enough. Do you need to go to treatment? Do we need to show that these guys are more sophisticated right now, and we should stay always ahead of the curve and also understand what case needs what, and so we'll be able to address it.
Right. Yeah, no, that makes total sense. And those are actually 2 situations that I've encountered myself, where these arguments that the adjudicators make sometimes not very well founded, because, for example, the argument of, well, you only met them 3 times. I actually only meet with people 1 time, but I'm a forensic psychologist. This is what all forensic psychologists do. When a person's in detention, you go to jail, typically it's just done. And we were trained to answer the referral question, the psycho-legal question. So it's not therapy. And you can make it look like it was therapy, but then again, it's unethical because we can't evaluate our own patients. So for years now, I've been including a footnote explaining that this is how I've been trained, this is how we do it, this is good enough, or more than good enough, right? And treating the people or evaluating people that I treat is considered a dual relationship, which also happens to attorneys as well. So that's why we wouldn't do it. And then in terms of recommending treatment, it's something that we've struggled with, because on the one hand, you want to say, this is so bad that this person needs treatment. But then the adjudicator might say, okay, well, clearly it's not that bad because they're not in treatment, or they didn't follow the clinician's orders. So one way that I get around it is I explain why they're unlikely to seek treatment. Or they might say, I know I need it, I want it, I just can't afford it, I don't have the time, I don't have the resources, something that sort of answers that question, the adjudicator's argument that it must not be that bad.
I think that helps a lot, obviously. but also the fact that we as attorneys, what we do is we also include additional evidence to show that, yeah, that was the main report, but the client also is doing other things to support this. So it doesn't all fall on you as, because now I know what they want. And so we try to kind of supplement that.
Right. I love that. Yeah, I like that. It doesn't all fall on us. Because I think some
Yeah.
clinicians sort of take that stance that like, we're going to make or break a case. And honestly, sometimes the reports do, but it's not
Of course.
all on us.
Yeah.
Like, yeah.
And I also remember that we take portions of the report and we include it into our brief. And that's when the attorney's skill comes into play, because then we use that, but we also use other things like legal arguments and whatever to make the final brief and hopefully win the case.
That's exactly right. Yeah. So, along those same lines, are there sort of any terms or habits that you see in reports that tend to perhaps confuse or distract from the legal argument that you wish clinicians would just avoid?
I think we don't like when we see in the report where kind of like the clinician makes an opinion. I mean, it's never a bad opinion, but some sort of an opinion about the applicant, which already formed in the mind of the officer, which makes it harder for us to kind of like navigate the story. What I mean by that is that, let's say, the report is that he's a hardworking person, something like that. We want to avoid stuff like that because we might change the narrative of our brief to show that the person maybe has issues to work, or maybe they're about to go do something else. So it's those kind of opinions that are not necessarily medical or some sort of making the person look less likable, but not intentionally, that could be a little bit hurting our overall efforts. And I know it's not done on purpose, but when we do catch that, we always request some kind of little bit of an adjustment, because I know sometimes the report comes from a different perspective that we're not always aligned. And that's why the communication with you guys is always helpful, because we say, that's a great report, but please, maybe you can change this or remove that, because that doesn't help me in my overall strategy.
Right. Yeah. And along those lines, the collaboration, like, what do you think makes a good working relationship with a clinician, from your perspective, that they be maybe flexible and open?
Yeah, I think it's good to have a conversation in the beginning sometimes, or through email or whatever the easiest way, just to kind of start with, this is kind of our plan in terms of what we want to do. What is our goal in terms of how we present this person's profile? And so we give that. And then as the report is drafted, we can always say, that's great, but that part might be confusing for a reader. So maybe you can adjust it. So it's all done in a very professional way. Just open communication is the best way, where we just say, okay, this is what I need. This is perfect. This will help me more if you adjust here or there.
Right. But short of just telling the clinician, this is what I want you to write, right? You stop there.
Yeah.
Right.
Well, no, we don't do that. I don't think anybody wants that.
Well, some people do that, actually.
I don't think we do that.
Yeah. So let's talk pitfalls. Let me give you a hypothetical. You get a report of a mental health assessment, and the clinician mentioned in the history, so this person, they met somebody and they had a long distance relationship and decided to move to the US. So she got a tourist visa in Mexico and came in with the intention of staying. Maybe they don't say it exactly with those words, but basically that's what it conveys, that she had decided ahead of time that she was going to come and stay in the US because her loved one lived here, but she entered legally because she entered with a tourist visa. What do you do if you see that in a report?
Typically, we would request, because, some of this information may hurt my client in the sense that it can perjure them, right? So if we find, and sometimes, again, this happens because there was a misunderstanding, or maybe the client said something they shouldn't have said, but they just, they said what they were supposed to say, right? So if we catch something like that could hurt our clients, we will request.
How would it hurt the clients? Yeah, explain it for those clinicians who wouldn't understand how saying something as innocuous as that can actually hurt a client's case.
Well, for example, I'll give you the most common example that we see. So let's say somebody says, I came to the United States in 99 and I stayed for 6 months. Then I had to leave. I came back again 3 years later. Then I left again. I was caught. Then I came back the next day. If all this is included in the report, because there are some things that the person was only apprehended once, And so that's what's on the record. But the fact that he came in 99 or 96, nobody knows about that. Okay. If we disclose that in a report and it doesn't appear in any of his documents, now the immigration says, wait a minute, this is new information for us. We never, this doesn't appear in any of your immigration file. Now you're lying to us. That's number one. Number two, you have multiple entries. So now you have a lifetime bar, and this waiver is not going to help you anyway. You know what I mean? So these are the kind of things that can hurt, because when people start talking, they sometimes forget what they said to me or to anyone. Right.
Mm-hmm.
And so it's very important to make sure that these kind of things are not going to be there, because that multiple entry that we have no idea about and it doesn't appear in any of his documents suddenly appears in the report. That can kill the whole file.
Right. Right. And similar to then admitting that, I don't think anyone who enters the country, the officer will ask, what are you coming here to do? And I don't think that anyone saying, oh, I plan on living here with a tourist visa, they would be let in, right?
Clear admission on paper that they came here to commit fraud. As a tourist, they're coming to live here.
So they lied to the whatever immigration officer to let them in. They did not say, I was planning on staying.
Exactly.
So that's misrepresentation, fraud, and that would trigger a ground of inadmissibility, correct?
Correct. Exactly. Which is not something that we want, because if that happens, none of that is included in the original file we gave them. So it creates even more issues for our waivers. Right.
So it sounds like something that, what's wrong with saying that? It's the truth. But from this perspective, it can actually do a lot of harm.
Well, again, maybe it's the truth, but the point is that if it wasn't disclosed in all the immigration history of this person, and now he talks about it in the psychological report, that creates a big issue for us.
Right. And ultimately the question is, does the adjudicator really need to know this?
Correct. And that's kind of like why we make that decision.
Right. So have you actually noticed any trends in how psychological evaluations are being treated lately by USCIS officers or immigration judges since this new administration?
I haven't seen anything unreasonable, but I'm telling you from the example I gave you before, where they're a little bit more cautious about some of them, depends on which embassy and which consulate. And also, some of these officers are also looking at the bigger picture. So yeah, we have an evaluation, but what else is happening with this person? Are they really that bad, or is it just a report? So we are more careful right now about presenting a bigger picture to our clients.
Okay, well, that's where we're going to pause for now. This conversation with Jacob has been packed with insight, and there's still so much more to dive into. So if you're finding this helpful, and I hope you are, be sure to join me for part 2, where we're going to continue the discussion and go even deeper into the intersection of immigration law and clinical evaluations. So thanks for listening, and I'll see you in the next episode. I appreciate you spending time with me today. If you enjoyed this episode, share it with a fellow mental health provider who needs to hear it. And if you haven't already, hit subscribe so you don't miss my next one. See you then.